say that, especially, let's start with the sexual harassment cases. Often it's still the victim who has to prove her innocence. That is one. And connected to it is the fear, because when a woman calls out, the accused invariably gets away easily, it's seen, and more so, the victim faces defamation cases in many leading corporate. I can even tell you, sadly, it is happening in the media also. So, what is the situation? And this kind of a scenario, what is the health and infrastructure available?
So what I was saying was the entire concept of human rights jurisprudence, which is the foundation of almost everything that we're discussing today about equity and equality of opportunities. One of the most sacred rules of human rights jurisprudence is that there is a presumption of innocence. So the burden will always be on the accuser, which in more often than not is the victim, to prove that the crime occurred and the crime was committed by the person who's accused of it. Now, that being said, there are a lot of developments in the law that makes the process of proving this significantly easier. So, for example, in the context of sexual harassment itself, based on the 2013 law, the burden is no longer proving the case of sexual harassment beyond reasonable doubt, but it is a much lesser threshold known as preponderance of probability, because it has been given a civil character. Now, there are practical challenges, of course, the foremost being that early reporting is not something that we see very often. So more often than not, the reporting of the incident itself is quite belated. A lot of the evidence may or may not exist. There may not be ways to break the deadlock of what the victim is saying and what the accuser is saying. But increasingly, the judicial precedents that have come out have resolved the deadlock by leaning in favor of the victim and not the accused. So keeping these things in mind, I do not think that in principle there are those kind of legal impediments that existed when, say, for example, the Mathura gang rape case happened. There have been a lot of changes on the language of the law itself.
Yes.
But I think where the difficulty lies is in terms of the infrastructure and the means of enforcing the law. There is still a lot of ignorance. There is still a lot of misconceptions about what transpires, what are the rights and privileges that the witnesses in the inquiry proceedings get. So, for example, the victim now has a right not to be in face-to-face contact with the person accused of the crime. This is by way of a judgment of the Supreme Court, but this does not necessarily translate to a similar mechanism in the ICC inquiries, because they feel that these are principles applicable only to criminal proceedings and not to the proceedings before the ICC. So I think there is a need to create awareness. There's a need to create systems and better implement these laws. And more importantly, you need to create an atmosphere where reporting is easy, it is encouraged, and does not result in reprisals, because that is when early reporting happens. And the earlier the incident is reported, the greater the chances of some meaningful outcome being brought out through the inquiry proceedings.
Thanks for that, Ashok. When we are speaking of the legal options for women, whether it is not, and I'm not restricting this to only sexual harassment, any sort, there could be harassment at workplace, there could be discrimination, disparity in income, even, sudden termination. What are the legal options? Often this has happened, like I myself have faced when we were forced to get out, they make it so tough often for women that you just say, okay, let me just give it up. I would rather have my mental peace.
Right.
The legal recourse is very limited because you get labeled. You're told that if you approach the court, you will be labeled as a troublemaker, especially by the corporates. And two, the kind of money and time that is needed, that often women do not opt for it. And I'm not saying men don't face it, but when we see percentage-wise, then the picture is a little different.
Absolutely. I think the harsh reality of our judicial system or the legal system is that delay is a factor. I wish I could tell you that once the case is initiated, within 30 days, there will be an outcome, but that never happens. And though there have been some strides made in terms of, say, bringing out the Commercial Courts Act to ensure commercial matters get certain expedited disposal mechanisms, the same systems have not been extended to, say, ordinary cases of employees challenging the termination by the employer, right? And the other issue that I think is very relevant to the subject is, have we really evolved our Industrial Disputes Act? Because even today, when we think about our labor protection mechanisms, the concept of statutory protection is mostly afforded to the persons known as a worker, a workman, right? But employees who are earning plus salaries in a corporate setting may not necessarily enjoy the protection of the Industrial Disputes Act, which means challenging things like wrongful dismissal, having the benefit of prerequisite of domestic inquiry proceedings before termination is undertaken. These are not really set in black and white. These are areas of gray in the realm of law, and that also means that challenging a wrongful termination because you've reported something becomes that much more difficult, time consuming, and expensive. So I think there is a need to actually expand the conversation to beyond just laws dealing with equity in the workplace. I think we need to have larger conversations about the labor code, about the Industrial Disputes Act, about the standing orders, ensure that the scope and ambit of the protection granted expands, evolves, and catches up with the times. And I think as long as we don't do that, the problem statements that you have identified will continue to be pervasive, which in itself is a deterrent to early reporting.